Good afternoon, everyone, and can I give you the usual reminder that social distancing measures are in place in the Chamber and right across the Holyrood campus. And the next item of business is a debate on motion 24095 in the name of Murdo Fraser on the Crown Office. Would those members who wish to speak in the debate please press your request to speak buttons if you're in the Chamber, and if you are remote, are in the chat box. And I call on Murdo Fraser to speak to and move the motion for up to 7 minutes, please.
Thank you, Deputy Presiding Officer. Yesterday, the Lord Advocate made a statement to Parliament in relation to the malicious prosecutions of David Whitehouse and Paul Clark, formerly administrators of Rangers Football Club plc. Whilst that statement was very welcome, and we had been calling for it for some time, there is more that needs to be said on these very serious matters. And for that reason, we have called a debate today on my motion. Before getting into the substance of my remarks, I should make two preliminary comments. Firstly, I should declare my interest as a member of the Law Society of Scotland, although not currently practising as a solicitor. Secondly, I am aware that there are currently live proceedings in relation to the cases of 5 individuals, and I do not intend to comment on those, but rather concentrate on the cases of Whitehouse and Clark, which were referred to in the Lord Advocate's statement yesterday. Presiding Officer, David Whitehouse and Paul Clark were partners in the international insolvency firm Duff and Phelps and handled the administration of Rangers Football Club plc. In November 2014, they were taken from their homes in the south of England on a Friday morning and driven to Glasgow, arriving too late in the day to appear in court, a timing they believe was deliberate. They were then held in police custody until the Monday morning, left in cells without a mattress to sleep on, with lights burning throughout the nights, and being checked on hourly as they were deemed to be on suicide watch. They were, in their own words, treated as if they were terrorists. And yet these were individuals who had committed no crime, nor was there any proper evidential base for them to be indicted. Their detention has been deemed to be a breach of Article 5 of the European Convention on Human Rights. Their prosecution, it has now been admitted by the Lord Advocate, was malicious. The experience that these innocent individuals suffered is horrific, and understandably, it has had a major psychological impact on them both. In February 2016, all charges against Clark and Whitehouse were dismissed, and they were told in May of that year that no further proceedings would be taken against them. They were both free men. The issue we have to understand is how this could possibly happen. What happened to Whitehouse and Clark is simply incredible. It is what we might expect to see in a third world dictatorship, not in Scotland in the 21st century. And despite the Lord Advocate's welcome statement yesterday, we are still no closer to an explanation as to how and why these individuals were victims of a malicious prosecution, who authorised the action against them, or what the motivations behind that were. But there is more to this case than simply those issues, significant as they are. Because Whitehouse and Clark then initiated civil action for damages against the Lord Advocate, winning a landmark case and persuading the Court of Session that he did not have immunity from common law liability. They were fortunate in having the resources to be able to pursue such a case. Many others in similar circumstances would not have been so lucky. Whitehouse and Clark have now been paid each the sum of £10.5 million in damages, together with another £3 million in legal costs. The Lord Advocate confirmed yesterday that these damages have been paid with a tax indemnity, meaning that should HMRC come against them for tax, then the additional cost will also be met by the Crown Office, potentially doubling the payout. And the £24 million here may just be the tip of the iceberg. With another 5 cases still to be heard, the total sum may well reach £100 million, or perhaps even more. Presiding Officer, at a time when Police Scotland are crying out for additional resources, at a time when every single member in this chamber is facing daily demands from constituents, whether individuals or from businesses, for more support due to the COVID crisis, it is simply extraordinary and outrageous that such vast sums of public money are being paid out as a result of catastrophic failures within the Crown Office. There is so much here that has gone wrong that needs to have a light shone on it. The only connection between these 7 individuals was their association with Rangers Football Club. What was the motivation of the Crown Office in pursuing them, given the lack of evidence of any crime having been committed? What was the role of the then Lord Advocate, Frank Mulholland, now a High Court judge? In any democracy where the rule of law is respected, it is essential that there is full public confidence in the prosecution system. That is precisely why we need answers to all these questions. And the public need to be reassured that what we have just seen can never happen again. Yesterday, the Lord Advocate advised that there had been an investigation undertaken by a legal team instructed by him. Whilst I am sure that that was a valuable exercise, from the outside, it looks like the Crown Office marking its own homework. There will not be public confidence in any inquiry unless it is conducted externally and done in public. The Lord Advocate said yesterday that there was no evidence of criminality here. That statement is directly challenged by David Whitehouse, with whom we spoke yesterday, who states that he holds information about the role of Frank Mulholland in intervening personally to override decisions made by prosecutors in his office in this case. We know already that there are questions of criminality within the Crown Office, and it would be outrageous for these to be investigated internally. The Crown Office cannot prosecute itself. Presiding Officer, that is why my motion today is calling for a full, independent and public inquiry conducted by a member of the judiciary, and one from outside Scotland, one from one of the other home nations, because that is the only way that the findings of any inquiry will have credibility in the eyes of both the legal profession and the Scottish public. Presiding Officer, this whole episode is an unprecedented scandal in Scottish legal history. Whether this has happened due to incompetence or corruption is something that has to be exposed. These are not issues that can be brushed under the carpet. To restore public confidence, we need a full, independent inquiry. That is the point made in my motion this afternoon, and I hope it will have the support of the Chamber. And I move the motion in my name. Thank you.
Thank you, Mr Fraser. And I now call on the Lord Advocate to speak to and move Amendment 24095.2 for up to 6 minutes. Please, Mr Wolfe.
Thank you, Deputy Presiding Officer. As I accepted in my statement yesterday, this case represents a serious failure in the system of criminal prosecution, and no one should doubt that I recognise the legitimate questions which it raises. I've committed the Crown to releasing further information when it is possible to do so, and I committed myself and the Crown to supporting a process of inquiry once related legal proceedings have concluded. Other civil cases are currently pending, and my obligation to the rule of law in those cases and otherwise impose constraints on what I can say at this time. In one of those cases, there is likely to be a hearing of evidence. So far as criminal allegations are concerned, as I explained yesterday, I am putting in place arrangements, including the involvement of external senior counsel with no previous involvement in these matters, to ensure that any allegations of criminal conduct will be considered fairly and objectively. And if criminal proceedings do ensue, those must take their course before any inquiry could proceed. The timescale for conclusion of those matters cannot presently be known, but let me be clear that I agree with Mr Fraser that thereafter there should be a process of inquiry, that inquiry should be transparent and independent, and that it should be led by a judge. Certainly.
Murdo Fraser.
I'm obliged to the Lord Advocate for giving way. It seems that there's a very minor point of difference between us on where we should go from here. Our request would be that that judge is not from the Scottish bench, given the former Lord Advocate's role on the Scottish bench, but it should be from another jurisdiction within the United Kingdom. Would the Lord Advocate agree with me?
Can I say I entirely agree the judge appointed would require to be demonstrably independent and command confidence in that regard, and it may well be appropriate to appoint a judge from out with Scotland. However, it would be premature at this time to conclude that when the time comes to establish the inquiry, there is no Scottish judge that could satisfy that requirement. The inquiry should be rigorous, independent, fully resourced and able to address effectively all the issues which require to be examined. Rhoda Grant, in her amendment, is right to draw attention to the need to consider the investigation and prosecution process in its entirety, including the role of the police, and I invite members to support her amendment. The only point where I depart from the substance of Murdo Fraser's motion is that he seeks to prejudge the particular model and type of inquiry to be selected. I should be clear that I do not rule out a statutory public inquiry. For aught yet seen, that may be the right way forward. But other models and forms of inquiry are available and equally should not at this stage be ruled out. By way of example, Lord Fraser of Carmiley's inquiry into the construction of this Parliament building was a non-statutory inquiry commissioned by Scottish ministers. And what happened following the acquittal in 2000 of an accused individual in respect of the murder of Sarjit Singh Chokar illustrates the point. The then Lord Advocate Colin Boyd commissioned Sir Anthony Campbell, a Northern Ireland judge, to undertake a non-statutory inquiry into the Crown's decision-making in that case. And he and the then Minister of Justice commissioned Dr. Raj Jandu to undertake a non-statutory inquiry into the liaison arrangements between the police, the Procurator Fiscal Service and the Crown Office and the family of the deceased. Those inquiries were, I won't just now, thank you. Those inquiries were completed within 7 and 10 months respectively. They generated robust and important conclusions, and the reports of those inquiries were laid before and debated in this Parliament. The time to address the form of the inquiry and the time to address the identity of the judge who should undertake it will be when all related matters have concluded. At that time, it's likely that more information will be in the public domain. And at that time, this matter should and will be brought back to this Parliament with the proposed arrangements for establishing the inquiry. As I explained yesterday, this case involved significant departures from the standard processes which routinely ensure that High Court cases have a proper basis. The seriousness of this case, its unprecedented nature, and the legitimate issues which it raises for inquiry should not obscure the truth that day in and day out Scotland's public prosecutors fulfil their responsibilities fairly, independently and with integrity. For my part, I'm proud of their work, which is reported daily in your news reports. They make hard decisions on behalf of us all, and those are tested and scrutinised by defence lawyers and by the court. They prosecute cases of every description, including murders, sexual offences, serious organised crime, serious financial crime, and crimes of violence and dishonesty which cause harm in our communities. By reason of the work they do and the way that they do it, Scotland's public prosecutors have earned and deserve your continuing confidence. And in making that point, which I do invite the Chamber to take seriously, I in no way wish to suggest or to diminish the seriousness of this particular case, or indeed the legitimate questions and issues which are raised. So having identified what in fact is perhaps a narrow point of difference in terms of the substance of the matter, I move the amendment in my name to the motion.
Thank you, Lord Advocate. And I now call on Rhoda Grant to speak to and move Amendment 24095.1 for up to 5 minutes. Please, Ms Grant.
Thank you, Presiding Officer. This is an extremely concerning issue, not just to those people involved, but also to the Scottish justice system. If we set aside the word malicious for the moment, this is shocking whether or not malice was involved. The Lord Advocate made a statement yesterday, and I appreciate that he could not be wholly forthcoming while cases had not been concluded, and this, of course, took place before his appointment. However, what he did say was worrying. To arrest and then detain people means suspicions exist at a level of criminality that could cause public harm. To then discover that there was no evidence against them to countenance such action is shocking. In yesterday's statement, we're told that Mr Clark and Mr Whitehouse were arrested initially in November 2014. They then appeared in court on separate charges in September 2015. The Lord Advocate told us yesterday that at that time, essential investigations were still ongoing in respect of charges that derived from the November 14 petition, and there was evidence available that was objectively, obviously inconsistent with charges against the two accused that derived from the September 2015 petition. Why then was the case being pursued at that time when there was obvious inconsistencies? Despite this, in December 2015, a second indictment was served superseding the first indictment. However, in February 2016, Crown Counsel withdrew certain charges and the court dismissed the rest. That was a full 5 months after it was obvious that there were inconsistencies between the two lots of charges. What is also clear is that this was not only mishandled by the Crown and Procurator Fiscal Service, as we understand the police are also being pursued for damages in this case, and we should be able to trust both those organisations to be beyond reproach. We should be able to expect them to question each other, to challenge each other, and to provide checks and balances to each other. And that brings me to our amendment. We agree with the motion that this requires an independent public inquiry because it undermines our justice system. However, we cannot do that without looking at the role of the police as well. We expect there to be enough tension between those two organisations that such things could not happen. Enough questioning, enough scrutiny. The costs to compensate for this mess come out of the public purse. We do not yet know the full cost, both in terms of compensation, but also costs accrued for the legal process in dealing with this failure and in correcting the processes that will have been found wanting. We have yet to discover the extent of the roll-off and compensation being sought from Police Scotland, which again falls to the public purse. Which budgets are these funds coming from, and what will have to be cut to pay for it? Let us be clear, services will need to be cut to provide this compensation. While I can't be alone in thinking the level of compensation based on earnings is obscene and calls into question the very values of our society, it is also sickening that frontline workers saving lives daily, those being paid the minimum wage in a gig economy, will have to fund it. Sadly, even a modest pay rise for them is grudged, even during a global pandemic. This, if anything, shines a light onto what is wrong with our society and what we need to put right. One also wonders if these two men would have had the means to access justice if they had been paid the minimum wage. However, that's a debate for another day, but it is one we must have. Presiding Officer, we must have transparency in this whole process. These legal and policing institutions can only work with the consent of the public. To have that consent, they must also have trust. Trust that justice is carried out fairly. This case damages that trust. We must ensure that our justice system is fit for purpose, and the only way to do that is to have a public inquiry, led by someone whose independence and legitimacy cannot be questioned. They must look at the role of both the Crown and Procurator Fiscal Service and also the role of Police Scotland. I move the amendment in my name.
Thank you. And I now call Liam MacArthur for up to 4 minutes, please.
Thank you very much, Deputy Presiding Officer. Obviously, we had the statement to Parliament yesterday afternoon where we heard from the Lord Advocate, but I think a further opportunity to consider in more detail the facts and the implication of the scandal is required, and therefore I thank Murdo Fraser for bringing this debate today. This is a scandal. In financial terms, as I said yesterday, it's up with Bifab and Ferguson's shipyard. £24 million so far, and the prospect, as the Lord Advocate has acknowledged, of this number increasing potentially very significantly. It's a colossal waste of taxpayers' money. However the Finance Secretary chooses to plug this deep and expanding hole, it will come at a cost to other areas of public spending. This at a time, as others have observed, when there is already no shortage of demands on those resources. Every day, like other MSP colleagues, I'm contacted by constituents who are struggling. Business owners crying out for lifeline support to stay afloat. Families desperate to know how the government plans to make up the lost ground in their children's education. And mental health services that were in crisis before the pandemic, but are now under unprecedented strain. To be clear, this is tens, perhaps many tens of millions of pounds that could have been spent on pandemic business support, education catch-up, or investment in mental health. Instead, it's being used to foot the bill for a malicious prosecution that should never have happened in the first place. We need to understand why this has happened, who was responsible, and how such grievous mistakes went unchecked for so long. With the overturning of Hester leaving the Lord Advocate liable for any other historic errors, we also need a clear understanding of what that might mean. The Deputy Presiding Officer, over and above the crippling financial costs, these blunders come at a reputational cost too. While the Lord Advocate deserves credit for his action in seeking to address grave errors made prior to him taking up post, these events will inevitably shake public confidence and trust in the Crown Office. That's why we need a full, independent inquiry led by a judge from Out With Scotland, and why steps to put this in place should be taken now, even if the inquiry itself must await the conclusion of outstanding complaints. But it's why we must also recognise the failings in the current arrangements, failings that have been the subject of debate since the establishment of this Parliament. I have the greatest of respect for the current Lord Advocate. However, over recent years, the evidence has been building the Crown Office is in need of reform. The wholly unacceptable delays in fatal accident inquiries are perhaps the most striking example, but this reflects systemic problems arising from workload pressures and a failure to get the right checks and balances in place. Ultimately, Deputy Presiding Officer, the Lord Advocate faces uncomfortable tensions, if not outright conflicts. As head of the Prosecution Service, the Lord Advocate requires to be scrupulously apolitical. At the same time, he is the Scottish Government's own lawyer, attending the vast majority of Cabinet meetings. He is responsible for the investigation of deaths and calling fatal accident inquiries, even when families believe the actions of Scottish public sector bodies may have contributed to those deaths. The personal integrity of the current Lord Advocate is not in question, but there is a question as to whether any single advocate, however capable and humane, should be asked to carry out so many tasks with so many competing interests. Deputy Presiding Officer, the case for Crown Office reform is now compelling, as is the need for a judge-led inquiry into the shambles of these malicious prosecutions. Meantime, this SNP government must now explain how the costs of this shambles are to be met. The public deserves to know which services will be expected to pay the price for the incompetence that lies at the heart of this latest costly fiasco. Scottish Liberal Democrats will support the motion and the amendment in Rhoda Grant's name at decision time this evening. Thank you.
Now call John Finney, please, for up to 4 minutes.
Thank you, Presiding Officer. At decision time tonight, the Greens will be supporting the amendment in James Wolfe's name and the amendment in Rhoda Grant's name, the totality of which is more measured language than the motion and a more realistic timeframe. Unprecedented's a word that's been used, and that might be seen as being reassurance. I'm not in any way reassured by that. We're told that this case was exceptional in terms of scale and complexity, but nonetheless, the higher standards we've come to respect the Crown Office Procurator Service good folk should have applied. And of course, COPFS is serviced by the police and note the claims against the police, and that's why it's appropriate that we support the Labour amendment. Can I draw a distinction between the post holder and the person? I've no issues with the action of James Wolfe. Indeed, I commend his leadership in confronting the significant shortcomings he's inherited and accepted responsibility for. He rightly relied on the established legal authority that the Lord Advocate was immune from common law ability, and we know that that was overturned by the inner house. And that allowed the claims to proceed. But what we need to understand is the fullest consequences of that decision. What would have happened if the 1961 Hester versus MacDonald decision had stood? Presumably, we wouldn't have seen the financial ramifications, but it wouldn't have negated any of the wrongdoing. And what are the implications beyond this case? Deeply worrying facts have emerged. Actions indefensible in law And that goes beyond the argument of it's a big organisation, mistakes happen. And we need to look no further than south of the border, where malicious prosecution isn't a rare thing. These decisions proceeded without probable cause, without a proper evidential basis, in circumstances which met the legal test for malicious prosecution. Can you imagine being subjected to that by the state? And the gentlemen who were wrongly treated in that way deserve to have a full and frank apology and to be rightly compensated. I admit to some confusion about the Lord Advocate's statement about the legal test and the terms malice. If the acceptance of liability didn't depend on any individual being malicious in the popular sense, to quote Lord Advocate, nonetheless it's individual actions, unlawful actions, that bring us here. And someone, an individual, has sanctioned that. Profound departures, no proper basis for prosecution, and very disturbing to hear your head of prosecution admit breaches of Article 5 and Article 8 of ECHR. This case was in the public domain, Presiding Officer. It was followed in very great detail. Most cases don't have that level of public exposure. The two pursuers were very high earning, and the damages reflect that. I wonder what if the individuals wronged in this way were unemployed labourers? What level of redress or financial compensation might they have received? Indeed, would there be the same level of outrage some quarters? So what I believe we need to understand from the Lord Advocate is whether the acknowledged shortcomings in this case applied in other, perhaps less high-profile cases too. Whether professional, public insurance, indemnity, or perhaps a lack thereof, and that's not his features in this case, and assurance wouldn't be an excuse for the wrongdoing. What steps the Lord Advocate will take to ensure public confidence, because public confidence, just as policing by consent, the public are pivotal in this. It's something that's done for them rather than to them. And the public might reasonably say, if this can happen in this case with all that publicity, what chance do I have against that system? Finally, Presiding Officer, we do need an independent, robust, judge-led inquiry, which would cover the police. I wouldn't restrict it to the home countries. I think the Republic of Ireland have many qualified people for that. We need to ensure public reassurance more than anything else. Thank you.
Thank you very much, and we'll move to the open debate speakers. And first of all, please, Adam Tompkins, followed by Rona Mackay.
Thank you, Presiding Officer. I want to quote to you to start with from a letter sent to me as convener of the Justice Committee by the Lord Advocate on the 1st of February. In Scotland, he said, all prosecution decisions are made by public prosecutors within the system of criminal prosecution for which the Lord Advocate, acting independently of any other person, is responsible. It is for the Lord Advocate, as head of the systems of criminal prosecution in Scotland, to put in place the appropriate policies and procedures for decision-making in any particular type of case. Now, that letter concerned an amendment to the hate crime bill that the Lord Advocate is seeking to resist. But the points he makes in it are both correct in law and of general application. There is one person, and one person only, who is responsible for the malicious prosecution of David Whitehouse and Paul Clark. That person is the Lord Advocate. When he was Lord Advocate, Frank Mulholland went out of his way to see to it that two innocent men were hounded by the state. The High Court in England ruled that the actions taken against these men were an abuse of state power. In any normal country, Presiding Officer, heads would roll. That man, Frank Mulholland, is now a Court of Session judge. Now, judges are quite rightly not accountable to parliaments for their decisions. And that's why nothing short of a full, open, public inquiry chaired by a judge from another jurisdiction must be appointed to get to the bottom of this outrage. Now, the Lord Advocate is, of course, accountable to this Parliament. Yesterday, James Wolfe gave a statement to the Chamber and fielded questions. Fielded questions, but did not answer them. I asked him the perfectly simple and straightforward question of whether his predecessor's abuse of state power was caused by his incompetence or by corruption. But Mr. Wolff could not, or would not, answer even a question as basic as that. Now, I believe, as others have said, that Mr. Wolff is an honourable man. But what he said yesterday leaves a great deal to be desired. What we heard was not an account of how on earth it was that the Crown Office was not merely permitted but encouraged to indulge in a malicious prosecution of innocent men. What we heard was a, frankly, through the looking glass statement, culminating in Mr. Wolff's preposterous claim that we have malicious prosecution here, but somehow no malice. This beggars belief. There can have been no malicious prosecution unless someone acted with spite, with malice, or in bad faith. And there is no mystery as to who constitutionally this was. It was the Lord Advocate. Presiding Officer, we have an accountability crisis in Scotland. We have a parliament so broken it doesn't even know when it's being misled anymore. We have a committee investigating how the government investigated complaints of sexual misconduct, which can neither publish nor even hear evidence that goes to the core of its remit. We have a government which, unique in Europe, sought to use the COVID pandemic to insulate itself from freedom of information laws. And wherever we look, we have taxpayers' money wasted. Wasted on coaching civil servants to dissemble to Parliament. Wasted on lawyers' fees, wasted on Derek Mackay's salary, and wasted, of course, in compensating two innocent men who were hounded by the state in the most egregious abuse of power. And all this time, the perpetrators sit untouched.
You have to come
Frank
to
Mulholland's judgment as Scotland's prosecutor, I'll say that again, all this time the perpetrators sit untouched. Frank Mulholland's judgment as Scotland's prosecutor is in the dock, while Frank Mulholland himself sits in judgment. It stinks, presiding officer, and do you know what it stinks of? It stinks of corruption.
Can I just say at this point that we are rather short of time, so any time over will have to be taken off other speeches. I call on Rona Mackay to be followed by Daniel Johnson.
Thank you, Presiding Officer. We know that the debate on the motion legitimately brought forward by the Conservative Party really shouldn't have had to take place. The facts of the matter are that there was a serious, unprecedented judicial error made which has indeed been costly to the taxpayer. It's important to say at the outset, of course, that the current Lord Advocate in the Chamber again today was not in his post at that time, but he has acknowledged that it is his responsibility now to apologise and answer questions on the issue, which he did in a statement to Parliament yesterday. He's confirmed that once all related legal proceedings are completed, there should be a transparent process of a judge-led inquiry. He's also confirmed today that all options are on the table and the government does not have an objection to someone out with Scotland leading that inquiry. However, these matters should be properly considered at that time. Presiding Officer, the seriousness of what happened in this case should not obscure the truth that day in and day out, Scotland's public prosecutors and the staff who support them fulfil their responsibilities with professionalism and skill. As a member of the Justice Committee since 2016, I've witnessed this numerous times during their cooperation with the committee. They have a justified reputation for fairness, integrity and independence. Scottish prosecutors and the Crown Office and Procurator Fiscal Service have an established reputation for fairness, integrity and independence. And there's no doubt that they have tackled the unprecedented challenges thrown up by COVID-19 in an exemplary manner. That said, in this case, there was a very serious failure in the system of prosecution, and it didn't live up to the standards which the public and this Parliament are entitled to expect, and which the Crown Office and Procurator Fiscal Service expects of itself, as acknowledged by the Lord Advocate. However, we move on and lessons have been learned. The Lord Advocate has stressed that nothing like this should ever happen again. He confirmed in the Chamber yesterday that the recognition process has been reinforced. New arrangements for the management and oversight of large and complex cases has been established to safeguard against anything like this happening again. Crucially, arrangements have been made so that the settlements will not affect the service the Crown Office provides to victims and witnesses. The Finance Secretary has outlined the budget for 2021-22, including the budget for the Crown Office and Procurator Fiscal Service, and it's now for the Justice Committee to scrutinise that budget. But the Cabinet Secretary has confirmed that the payments will not require to be met from the COPS resource allocation, which was announced as part of the Scottish Government budget last week. That allocation involves an increase in COPFS funding from £1,024.9 million in 2020 to 21 to £146.8 million in 2021 to 22, representing an increased resource allocation of £21.9 million and additional capital funding of £0.5 million. So in conclusion, Presiding Officer, there's absolutely no dispute that this is a unique and hugely regrettable case, which must never be repeated. But I'm confident that steps are now in place to make sure that it never does. Thank you.
Thank you. Daniel Johnson, followed by Shona Robson, please.
Thank you, Deputy Presiding Officer. I, much like John Finney, find myself using the words unprecedented and extraordinary. And where sometimes those words can be rhetoric and hyperbole, I think in this debate, they barely state the seriousness of what has happened here. And I think despite, the assertions from the Lord Advocate and much as we've heard from Rona Mackay, we have not heard why we should have confidence that these matters are resolved and cannot happen again. We look at the Lord Advocate's statement yesterday, for him to conclude that prosecutions proceeded without probable cause, without a proper evidential basis, is extremely serious in and of itself and should worry everyone, not just in this Parliament, but across Scotland. For the results of this extraordinary lapse from this important public body to be costing the public between £24 million and £100 million simply underlines what is an absolute scandal. In any other times, this would be a national crisis in our justice system. And it should not be allowed to be obscured because we are facing a global pandemic, or indeed there are other significant issues facing us. Because the rhetoric in these circumstances are justified. There are serious questions about the rule of law. There are serious questions about our justice system, and there are serious questions about our democracy. Now, the Lord Advocate, in his opening remarks, said that prosecutors deserve our confidence and respect. Quite simply, the questions raised by this mean that we cannot currently have confidence in their ability to do their job. We cannot have confidence that things are happening as they should. Quite simply, we do not have answers to the circumstances, the motives, or indeed the culpability of what has happened. Simply put, the what, the why, and the who. What procedures were in place? Why did they fail? They were apparently a significant departure from what was expected, but why did that happen, and how was that allowed to happen? Why did this happen? What was the motivation, rationale, and the justification for this departure? And who made these decisions? And this is critical. All too often, when it comes to institutional failure such as this, individuals hide behind the collective whole. But the simple reality is this. In this prosecution, certain individuals must have made decisions which meant that this prosecution proceeded. We need to know who they are and what those decisions were, and they need to be held to account for them. And in terms of that who, I acknowledge, as others do, that the current incumbent of the office of Lord Advocate has been forthcoming. He has made himself accountable, but he is clearly not responsible for those decisions. We need those who are responsible for those decisions be held fully to account, and indeed must be indeed face the consequences of those decisions. But more fundamentally than this, there are important principles at stake. We have fundamental safeguards, some of the most fundamental points in our justice system, which are there to safeguard individuals from malicious prosecution, from being harassed by the power of the state. That is why you cannot incriminate yourself. It is why we have some of them are historic principles such as double jeopardy and other principles such as those. That's why we have principle of corroboration. These are so that the state cannot harass the individual, because we recognise the power of the state and the inherent imbalance that there exists between the individual and the state. Now, it so happens that these individuals are individuals of means that were able to defend themselves. But we have to ask the question of what would happen in other circumstances. We have to ask the question, has this happened before? Are there other such circumstances which simply have not come to light? More broadly, there are fundamental questions in our justice system, questions about the police and the proximity of the government, prosecution and the police, which only a judge-led independent inquiry can answer. Thank you very much.
The last speaker in our open debate is Shona Robson.
Thank you, Presiding Officer. I think it's fair to say that across the Chamber today there is broad agreement that in this instance there was a failure in the system of prosecution, and that that failure has been admitted to by the Lord Advocate. Whilst saying that it's important to recognise that what has happened was and is unprecedented in legal history, it is also important to recognise this because it's essential to reassure the public that each day the Scottish legal system works in a robust and transparent manner to ensure that fair and accountable justice is administered. Each day, all those involved in the justice system work with great professionalism and dedication, and we shouldn't lose sight of that fact. As we know, having concluded actions only last week, the Lord Advocate has taken the first opportunity yesterday to address Parliament on the situation and, in his words, begin the process of public and parliamentary accountability, and to reiterate the commitment that the Crown has given to that process. And I welcome that commitment and look forward to the further parliamentary and public scrutiny of a transparent inquiry into the situation as called for in today's motion. We also know that the case was exceptional in its scale and complexity, and that certain legal proceedings are still ongoing. Therefore, in order to fully understand the implications of the situation and provide for the opportunity to undertake as wide-reaching and transparent an inquiry as possible, it would be prudent to ensure that all proceedings have finished before establishing the inquiry as called for in the motion. This will also allow time and opportunity to ensure that any further changes required will be well established and thorough. I welcome the fact that the Lord Advocate has already undertaken changes to reinforce the precognition process, and that new arrangements for the management and oversight of large and complex cases have been put in place. It's also important to note that assurances have been given that the settlement involved in this case will not affect the service that the Crown Office provides to victims and to witnesses. However, this is a very serious case and should be treated as such. In conclusion, Presiding Officer, I welcome the motion before us today and fully support an inquiry into this unprecedented situation. As to the makeup and timing of any such inquiry, I understand that the Government has no principal objection to someone out with Scotland leading it. However, I do believe it's prudent that any proceedings ongoing in relation to the case are concluded before an inquiry is undertaken, to allow us to learn as much as we can and ensure that the steps are taken to redress the situation are robust, transparent and effective. Thank you.
Thank you, everyone. We'll now move to the closing speeches, and we first of all have James Kelly for up to 4 minutes. Please, Mr. Kelly.
Thank you, Deputy Presiding Officer. This is an important debate that the Conservatives have brought forward this afternoon because the circumstances surrounding this are a scandal. It's not just that David Whitehouse and Paul Clark have been found to be maliciously prosecuted. It's the issues that flow from that. There are clear questions as to the processes and how things are operating within the Crown Office. We have two individuals who have been taken through the courts unfairly, and we have a vast sum of public money that's had to be paid out as a result of that. Yesterday, the Lord Advocate in the statement said that Clark and Whitehouse had been brought before court in November 2014 on petition, and he explained that it was then subject to the process of pre-recognition, saying that that involved a detailed narrative of the evidence and an analysis of whether the evidence is sufficient to support criminal charges. He then went on to say that in this case there had been a departure from normal practice, and that included precognition. Clearly, as Daniel Johnson said, there was no firm evidential basis in which to proceed with this case, and clearly that poses really serious questions for the Crown Office and the Procurator Fiscal Service. And we had the statement yesterday and the debate today, but we're no further forward as to who is responsible. As Murdo Fraser rightly highlighted, we need to know who took these decisions, who is responsible. Further to that, these two individuals were high earners and therefore were able to fund a substantial legal case in order to bring their case to justice. And as John Finney pointed out, if they were, on a more kind of average wage scale, people would not have been able to fund that. And there's a clear access to justice issue there. And I think this also leads to further issues, questions as to how the Crown Office is operating. Not everyone could have brought a defence in this case. So are there other cases like this? We know that there are issues around backlogs of cases, and I think there needs to be a fundamental review as to how the Crown Office operates. I think the other thing to say is that the sums involved here are astronomical. At least 24 million admitted so far, and that could run to as high as 100 million. This morning at the Finance Committee, I raised the issue with a reduction in the housing budget, and yet here we see, because of incompetence in part of the Crown Office, we see vast sums of money are going to have to be spent, and we deserve to know where in the budget that money is coming from. These questions need to be answered. So, in summing up, Deputy Presiding Officer, for the justice system to operate properly, the public and Parliament need to have confidence in that system. This case is undermining that confidence. So in order to move that forward, we do need a judge-led inquiry. We need it to proceed promptly. We need to hear the answers to these serious questions. And we also need not just proper lessons to be learned, but serious reform of the systems and processes at our Crown Office. Thank you.
Now calling Graham Day for up to 5 minutes, please, Minister.
Presiding Officer, I welcome today's debate for giving us an opportunity to consider a matter of genuine and legitimate public concern. The significance of the compensation paid in these cases cannot be ignored, nor can the backdrop to all of this, a serious failure in the process of prosecution, as the Lord Advocate has acknowledged. And whilst there are, quite properly, restrictions on what can be said about the cases themselves due to the ongoing legal proceedings, neither the Lord Advocate nor, let me confirm, the Government holds a contrary view to that. The Lord Advocate, in opening today and indeed during his statement on this issue yesterday, made clear his commitment to supporting parliamentary and public accountability at the right time once all of the related legal proceedings are completed. He also committed to a transparent process of inquiry which gets to the facts. I should not need to emphasise that the work of the Crown Office and the Procurator Fiscal Service as Scotland's public prosecution service is the responsibility of the Lord Advocate in his capacity as public prosecutor, and it's not that of the Scottish Ministers or the Scottish Government. But the Government amendment makes clear our support for the underlying principles of how this must be taken forward, to secure the explanation of how and why the malicious prosecution was proceeded with, as Murdo Fraser reasonably called for. The Lord Advocate has offered assurance that Parliament and the public can have confidence in the wider work of the Crown Office and Procurator Fiscal Service, and that lessons have been learned and changes been made. However, we recognise there must be full and open reflection and investigation of what occurred and the monetary and other consequences of that. There have been calls today for a judge-led inquiry. The Scottish Government's amendment to the motion for debate makes clear, as did the Lord Advocate in his opening speech, that there would be merit in such an approach. However, the amendment also makes clear that any such inquiry can only appropriately take place once all the relevant legal proceedings are concluded, and that's something I hope the Conservatives accept, but which isn't acknowledged in the original motion. The timing of any inquiry will be critical, and I hope that's something accepted across the chamber and not just by the Conservatives. Any inquiry must assess fully the circumstances of what has happened, but that inquiry can only effectively discharge that important task if there are no ongoing legal proceedings. Otherwise, there would be a danger that an inquiry process might prejudice those proceedings, and the inquiry itself would be at risk of not getting to the heart of what occurred. Therefore, the key issue is not the need for a process of inquiry, that's accepted, but rather the timing of that process and the precise form it will take. The Scottish Government does not have an in-principle objection to someone out with Scotland leading such an inquiry. However, these matters should properly be considered at the right time. Beyond this commitment, however, it would not be appropriate to say more today about the nature of the inquiry, statutory or non-statutory, or its detailed arrangements. That's for a future date. But if anyone, for whatever reason, doubts the Scottish Government's willingness to deliver a transparent examination of this matter, I would point them to the fact that we currently have statutory inquiries taking place into Sheku Bayu, hospitals and trams. There exists evidence of the commitment of the Scottish Government to establishing the truth, even when it can be uncomfortable to do so. Presiding Officer, whatever form of inquiry is chosen in respect of these prosecutions, the Scottish Government is committed to it being rigorous, independent, appropriately wide-ranging, fully resourced and empowered to get to the bottom of the issues and concerns that have been rightly raised. As soon as it's practical and possible, at the conclusion of all currently live proceedings, we can return to this matter and the precise specifics of how best it can be taken forward. That surely is the right and proper way to proceed. And it's essential, Presiding Officer, that we proceed in a right and proper way, not throwing around unsubstantiated allegations about individuals, but we're committed to obtaining the facts, to get the answers that members have rightly asked for today. Presiding Officer, I invite Parliament to support the Government amendment and that from Labour.
Thank you. And I now call Liam Kerr to wind up the debate, please, for around 6 minutes, please.
Thank you, Presiding Officer. I remind the Chamber that I am a practising solicitor and member of the Law Society of Scotland. Presiding Officer, at the outset of this debate, my colleague Murdo Fraser, in proposing the motion, used the word incredible. And the contents of the subsequent debate and contributions from members across the Chamber have at times been, in the truest sense of the word, incredible. Let us recap some of the facts that MSPs have described, and facts is what they are, because I shall limit myself to the cases of Whitehouse and Clark. I describe nothing that has not been accepted by the Lord Advocate in his statement yesterday, and studiously avoid anything which has yet to be concluded. Throughout the afternoon, we have heard that a pair of reputable professionals were engaged to do a high-profile and complex job, which was wholly within their expertise and competence. However, in November 2014, they were taken from their homes in England, driven to Glasgow, too late to appear in court, held in custody, apparently without a mattress and with the lights on all night, and checked hourly. From then until May 2016, the considerable weight of the Scottish criminal justice system is brought to bear upon them. But what we now know is that not only did their treatment breach the European Convention on Human Rights, but it was a malicious prosecution. Not a simple human error or obscure legal mistake, not an error of evidence suggesting the need for individuals to be taken through a criminal process to establish their guilt or otherwise. This is our system of prosecution admitting unequivocally that maliciously there was a move to throw innocent men behind bars and destroy their reputations. Malicious, Presiding Officer. What does that mean? Well, Adam Tompkins referenced the suggestion that we have a malicious prosecution but somehow no malice. As a result, we heard yesterday there was no criminal conduct. Now, whether or not malice means what the people of Scotland might popularly think it means, as an aside, I muse simply this. Malice is a personal act. An organisation cannot be malicious. Therefore, to draw his conclusions from the investigation that the Lord Advocate instructed, he must have identified one or more individuals with the requisite mens rea of the offence to conclude the prosecution was malicious. And what that is, as the Lord Advocate well knows, is per the dictum of Lord Justice Bailey in Bromage and Prosser, a wrongful act done intentionally without just cause or excuse. That, according to Quinn and Leatham, is proof of malice. So the Lord Advocate must have identified an individual who, in their duties, acted wrongfully and intentionally without just cause or excuse. Misconduct in public office is a crime. So the conclusion that there was no criminal conduct surely requires deep exploration by an inquiry to retain public confidence. In any event, innocent individuals carrying out their job lawfully have faced prosecution, not because of a suspicion that they've done anything wrong, but because of malicious intent by agents of the state. Now, to the best of my knowledge, there has never been another instance of malicious prosecution in Scots law. Yet, as Murdo Fraser put it, we are still no closer to an explanation as to how and why these individuals were victims of malicious prosecution, who authorised the action against them, or what the motivations behind that were. What we do know from the contributions this afternoon is that Scottish taxpayer has already paid out around £24 million in damages and legal costs, a figure which presumably does not include the legal costs of the state. We also heard it is not beyond the realms of possibility that that figure could rise to £100 million or more. And Rhoda Grant flagged we do not yet know from which budget that money will be taken. But as Liam MacArthur stated, this is a colossal waste of public money, which he rightly said could have been spent on education, on health, on business support. It is truly incredible. Now, in any democracy where the rule of law is respected, it is essential that there is full public confidence in the prosecution system. The Lord Advocate told me yesterday, this was a case in which the normal processes that routinely in every High Court case are followed were not, and the public should take reassurance from that. The prosecution system in Scotland is one which is robust, fair, independent, and upon which they can rely. But in a powerful contribution, Daniel Johnson stated, we have not heard why we should have confidence this can't happen again. There are fundamental questions. Indeed there are. And the Lord Advocate's reassurance is given absent the forensic public inquiry into what went wrong, who by, and why. And that is why it's necessary. In fact, imperative that a public inquiry is set up to investigate and shine light on what on earth happened here, why and on whose authority, and that it be full and comprehensive, which is why we are persuaded by the Labour amendment. Judge-led, but under a judge from a jurisdiction out with Scotland. The Lord Advocate suggests it premature to conclude that it need not be a Scottish judge. I cannot agree. Public confidence is key, and as Rhoda Grant put it, it is imperative there are no questions around legitimacy and independence in order that the public is reassured that what we have seen can never happen again. And that cannot and need not wait potentially years for all matters to be tied up. Shona Robeson is not correct that this should await everything completing. The extraordinary circumstances and costs of this scandal mean it simply cannot wait. Yet the indications are that the SNP disagree. The SNP, I think, intend not to support the proposition that the state seeking to criminalise innocent individuals with malicious intent is a reason to conduct the fullest possible inquiry, independent, judge-led from a judge outside Scotland, and public, which demands to know why malicious prosecutions were pursued in defiance of evidence, as the Murdo Fraser motion craves. Presiding Officer, to vote for anything other than in favour of the Fraser motion tonight would indeed be incredible. Thank you.
That concludes the debate on the Crown Office, and it's now time to move on to the next item of business.